Stefan Schmidt for InsiderIowa.com. This week, the Supreme Court came down with perhaps one of the most dramatic cases that you can imagine, and that is that the conservative majority of the court, basically in a 5-4 decision, ruled that government may not ban political spending by corporations, labor unions, and other organizations in candidate elections. Well, this is certainly a big change from what Teddy Roosevelt wanted and accomplished. Teddy Roosevelt, President Theodore Roosevelt, was very concerned about corporations basically unleashing a torrent of money to give to candidates and to basically overwhelm elections. This is a country where every citizen has one vote, and most people don't have a lot of money to add to that one vote in order to try and get the attention of candidates, and therefore when any group begins to pour enormous amounts of money into the process, it in some ways at least distorts the one man and woman vote that we all have, because it shifts power to those who can raise the largest amount of funds. Roosevelt banned corporate politics. He signed something called the Tillman Act in 1907, and then Congress, 40 years later, extended that in order to ban labor union spending on campaigns. The Tillman Act addressed corporations, and in many different court cases since then, the U.S. Supreme Court has upheld those laws. Most recently, of course, we had something called the McCain-Feingold campaign finance law, which tried to close some of the loopholes, and that McCain-Feingold law is now pretty much obsolete. The previous way that corporations and unions participated in politics, and I've said in one of my columns in InsiderIowa.com that there's been a ton of money flooding politics, so that isn't anything different. But before that, basically companies and unions had to solicit their members for voluntary donations, and the word voluntary in quotation marks, sometimes they put a little pressure on them, and they had to give it to political action committees. That is no longer necessary now. Unions and corporations can just go into their general fund, take out whatever money they need, and basically fund political causes. So the amount of money that's going to be spent is going to be much greater, and it's going to be much easier to do it. You don't have to find all the legal obstacles and either get around or jump over those. It will have a great impact. More special interest money will flow into the political process. And also, McCain-Feingold had a provision in it that limited spending during the final days of a political campaign. That's now looks like it's obsolete as well. Again, I'll reiterate what I said in my column in InsiderIowa.com, and that is that it just simply is a matter of volume, not of the actual quality of money in politics, because we have had escalating costs for political campaigns. I mean, the Obama-McCain campaign was outrageously expensive, and as you know, Senator McCain himself took public funding, but Senator Obama didn't. So it was a real giant bill for that. It looks like what will happen now is that corporations, organizations such as labor unions and so on, are basically going to be equated to individuals in terms of what would be called kind of freedom of speech. So the whole case hinged on whether or not limits on campaign money was an infringement on free speech. So now a big question comes up. Will the Supreme Court ruling that just came down also affect other restrictions on campaign spending? In other words, state regulations and others on that are legal now, and that the Federal Election Commission recognizes and supports, but that might now also have to be thrown out the window. There's a New Jersey has a thing called pay to play, which is a law, and there are bans sometimes on political spending, for example, by casinos, by banks, by insurance companies, and by utilities. You can guess why those are put into that category of not allowing them to give to campaigns in some cases. It's very possible that all of that will go out the window now. And then the question is whether Congress can step in and reform some of those laws that exist, and within the framework of the Supreme Court's ruling on this. Because remember, you always have to comply with the Supreme Court when you rewrite laws after a Supreme Court ruling comes down that you don't like. So we are entering another era now in American politics, and my own view is that if Americans are really mad enough and just find this unacceptable, that big, powerful interests are not going to have even more power than they had before, you are very likely could get a real voter uprising, and that voter uprising could have political consequences. I mean, voters could vote in a president or support a president who disagrees with this ruling, and give that president a big majority in Congress, so that the next Supreme Court appointments can be not so favorable to this particular position. Because remember, the Supreme Court is political, so this was definitely a decision with incredible political consequences. For conservatives, it's astonishing that the court would abandon so many years of practice and find something that no other Supreme Court has found in the Constitution. And also, it's disturbing that the court is becoming more and more active in specifically political judgments. The case of George W. Bush versus Al Gore in 2000, when the election was gridlocked, was one in which the Supreme Court of the United States basically suspended the counting of ballots, and in many ways will go down in history as George W. Bush essentially having been elected by the U.S. Supreme Court. I don't think that's very healthy. I think the court has been wonderful and terrific because it has tried to leave political decisions and political questions to the legislature and to the political process. So go to InsiderIowa.com, Iowa's only and best internet magazine, and you'll see a lot more on this and a lot of other good stuff. Thanks.